Good evening, everybody. We're going to make a start. I'm hoping as many. Yeah, you found the event. It's not exactly the easiest thing on Facebook to actually find it, but yeah, we're just going to kind of get going properly in a few minutes. But before we do so, there's just a few things we need to go through. So first of all, just welcome everyone. My name's Mike. I am a caseworker at JustUs in Bedford, which is a little homelessness advocacy service. I set JustUs up with John Allen, my colleague, back in 2014, and we've been just supporting people in the borough ever since, really. We've got backgrounds in the homelessness sector. And really, I'm hoping that the information we go through tonight will be incredibly helpful for you. I'm almost kind of looking at information which is the stuff I wish I'd knew in 2005 when I started in the sector, because certainly I had no idea about homelessness law back then. I didn't even know it existed. If someone said to me, what does statutory homelessness mean, I'd have no idea whatsoever. And so, we were essentially trying to help people who are homeless with both hands tied behind our backs. So as I say, this is really designed to kind of be of interest to people who work in the sector in some capacity, members of the public who are interested in the sector. And really, what we've found is that homelessness law is, it's almost like a magic wand in some cases, which, you can work with people and get them housed, people who have been homeless for very long periods of time, and get them properly housed as well, not into a night shelter or a hostel or a dormitory type accommodation. We're talking genuine home, something that they can kind of, close the door and feel it's theirs. So as I say, I'm going to try and pad out the next couple of minutes, so apologies if it seems boring already. It's going to get better, but essentially I know some people are still joining the group, so I'm just going to go through a couple of bits of admin before Araba and Jan start actually kind of tackling the questions that we've got. So first things first, I know this is going out on YouTube, through Facebook. A little tip: if you ever want to do a live broadcast, don't do it on Facebook. It's a real headache. But hopefully you are being able to hear this and watch this. So first things first, if you just want to put your, if you want to introduce yourselves in the comments section, say where you're from. I know we've got people coming from all over England this evening. And also, as the event progresses, if you have a question you want to ask the panel, put it in the comment section. We can't guarantee answering every question, obviously, because I think there's going to be a fair few. We've already had quite a few from different kind of places already. And what I'd say is with those is try and, don't ask really specific questions about very specific kind of obscure situations. Try and keep it big picture. I think you're much more likely to get an answer if you do it that way. Right, where are we up to? So, as I say, before we really get into it, I just want to thank everyone on the panel who's here tonight. Incredibly lucky to get this group of individuals together. I don't think we're going to see this mix of people again. So I think this hopefully be a really good event, and particularly the panel discussion as well, where we can kind of start sort of broadening out a little bit with the topics. What I'd kind of say is that we're going to do introductions properly a little bit later. But really, there's a couple of things I thought, as I say, in the next couple of minutes, I'm going to go through that might be of interest to you. So Sarah, for example, is a barrister at Doughty Street Chambers. I saw Sarah talk in an event just over a year ago, and it was just genuinely excellent. As I say, I'm not a lawyer, I'm a lay person. I found the event to be thoroughly engaging, and without, kind of trying to win any favour here, Sarah's kind of talk about Equality Act, the equality law and homelessness was really, really something I never really heard before. Was incredibly interesting, and I know she's chairing some of the bits and pieces next week. So there's essentially, if this is working correctly, a link should come up on the YouTube comment section now, which is a link to the event. As I say, it's covering a whole load of things, but the title is Housing and Justice. Housing inequality and justice in the COVID era, and I think it's well worth checking out. So have a little look on that link. Next up so we've got David Ford here tonight, who's the CEO of Expert Link. Again, I've been on some really quite incredible training run by David. So as one of my colleagues, it is not a typical training day. Let's say that much. It is something where it really kind of opens your eyes to a whole load of things that you wouldn't necessarily expect to see. So he's got some training courses coming up, which I guess are online in the current conditions. Again, hopefully there's a link there through to it. And I can't really do this event without plugging our own training. So we do a day course on homelessness law. Our next one is a week tomorrow on the 11th of December. Again, there'll be a link there to it. It's really just acts as an introduction to people who maybe either work in the sector already and aren't confident in housing law and homelessness law, and for people who are literally new to it, brand new to it. So again, reasonably priced on Zoom, and we get really good feedback. So I think it's a good day. I'm just got a little list here I'm ticking off. Couple other bits. Finally, I need to also just kind of say, our Facebook, on our Facebook page, JustUs Homelessness Advocacy, we have a group attached to it called Better Homelessness Practice, which is really a place for professionals and interested members of the public to ask what if questions. So it's not to ask you ask about your own situations. It's designed to share knowledge with people in the sector so that we can improve our ability to get people housed. Again, it's been going a few years now. It's there's some interesting discussions that I had in there. And then finally, and again, I'm not blowing smoke here, there are some great textbooks out there about homelessness law. And I would say Jan Luber's is my favourite. It is by far the most detailed. It is, and very accessible in terms of it's laid out in a way, even though it's, half a foot thick, it's laid out in a way which means you can easily access bits and pieces that you need to know at the time. So it's called Housing Allocations and Homelessness. And again, there's a link there just to get it. It's there's a new edition coming out next summer, so I appreciate some people might want to hang on until then. But if you actually look on that website, you'll see that there's a link to effectively a free version of it, and I know that is legit, so it's not a pirated or anything like that. So that is my bits and pieces out of the way. We're talking about homelessness tonight, obviously, and as part of that, from the start, we're going to be talking about some difficult situations. We're going to be talking about some distressing situations, because really the purpose of tonight is drawing together the theory of housing, of homelessness law, and real events, real people who are affected by these issues. And I'll talk more about that in a second. So, again, appreciate some of this content probably isn't suitable for children. And I think as well to say that in that comment section, feel free to ask questions, but don't ask them about your own situation. There are ways to kind of get that information, but it's on YouTube. Everyone's going to see it. In my opinion, you're better off just kind of either asking it in an anonymized way, kind of in the third person, or using one of the forums to kind of ask those questions. So again, I don't want people kind of sharing stuff on the YouTube comments and then regretting it later. So hopefully that will make sense. As I say, I'm going to hand over to Arabo in a second. But for me, just to kind of ground this all in the real world, because the legal profession, is full of jargon. It's often kind of seems accessible to the outside world, and yet, as I say, in many ways, it's the key to ending homelessness, in my opinion. So I'll give you a couple of anonymised case studies that we've seen this year kind of come through, just to kind of give you an idea of how bad the problem is in England of kind of gatekeeping and perverse decision making and just basically services not doing what they should be doing. So again, this is heavily anonymized, but I've kind of kept true to the substance of these cases. So I worked with a young guy called Matt. Matt had learning difficulties and a medical condition which meant he would lose consciousness sometimes. And whilst living in a hostel, he lost consciousness and was raped. In one sense, rape is not an unusual experience in the homeless sector, sadly. What was probably unusual was that actually the guy who did it got caught and was sentenced to prison, which again was a whole kind of world of kind of distress for that situation. Matt's mental health deteriorated. He ended up in a psychiatric unit and spent several months in there just getting treated and slowly recovering and kind of working out what's going to happen next. The psychiatric unit treated him and got him to a point where he was fit for discharge, but still obviously very vulnerable. He approached the local council. The local council, to cut a very long story short, said he wasn't priority need. He wasn't vulnerable. He was no more vulnerable than an average healthy and robust person. And so he started sleeping rough in the town that this was in. Professionals, both the council, the safeguarding team, the kind of the local outreach teams, the night shelter, all those kind of services, they would meet up every 2 weeks to basically discuss high-risk individuals in the town. And Matt was discussed every 2 weeks for between sort of three or 4 months. We never actually quite found out. And every time, essentially, they they identified that there was fresh abuse that had been alleged, that he was suffering more and more abuse, and yet services didn't challenge the non-priority decision. Because they didn't really know how, I would say, more than they were unwilling. And the council, basically didn't accept a fresh application, even though there was new information every time that this meeting happened. And eventually got to a point where Matt was referred to different services. He came to JustUs. We got Matt housed within 90 minutes of getting that phone call. And that wasn't because we're magic. It wasn't because we are, we didn't need to know much how homelessness law to actually achieve that. Essentially, we just needed to ask the right questions of council, and essentially Matt is still living safely and has done ever since, and was compensated for those failures. So that's one example, and I'm going to lay it on thick because I think this is important, and I'll make another point about that in a second. Another lady we work with, let's call her Kelly. She had a relationship breakdown, became homeless, sofa surfed for a little while, ended up running out of friends as it often happens. So she ended up kind of rough sleeping, and she became suicidal. She attempted suicide. Fortunately, was picked up by the ambulance. She came very close to killing herself. Genuinely, really was touch and go really in hospital. And after she'd recovered physically, they transferred her to an inpatient unit, where again she improved. Things improved. She kind of stabilised. They prepared her for discharge. Contacted the local council there, and the council said, yeah, not in priority need. No reason to think she might be in priority need. There was domestic abuse kind of inferred as well during the kind of course of that contact that she kind of left. And so she, started using the night shelter, using the rough sleeping services, became suicidal again, told services that she was suicidal, was essentially told again she wasn't in priority need still, and she tried to kill herself again, ended up back in hospital again, told her that she was non-priority. Again, at that point, it was referred to JustUs. And again, it was not a difficult job to successfully argue that she was in priority need. The code of guidance is very clear. If someone's been discharged from an inpatient psychiatric unit, it's likely they're vulnerable. So even before you knew all the other stuff, it was pretty obvious she was vulnerable. And again, once we kind of appealed that decision, things were sorted out. And again, she's living happily and has done ever since. So these are the kind of situations we see. It's not unusual for these situations to happen. They happen every day in probably most areas of the country, where vulnerable people are told there is no duty to them when there actually is. And I personally would see this as a scandal on the same scale as the Rotherham abuse scandal. Pretty much everyone in the sector knows this happens. It's tolerated. It's often blamed on the individual in the same way that the girls were kind of, it's their own fault. They bring it on themselves, that kind of mentality. People say, oh, they choose to be homeless or whatever. And so day in, day out, injustice kind of, occurs across the country. And it has a real damaging effect, not just on the individuals, it has a real damaging effect on society as a whole. And I'm hoping that during the course of Jan and Araba talking and during the panel as well, we can kind of maybe, provide some clarity of thought about these issues and actually work out how, what could be done about these things, because the lack of housing stock is not an act of God. It is something which is very much in humans' control to do something about in England. It's a question of, do we continue tolerating this stuff or not? So that's a longer introduction than I was anticipating, so I'm sorry for going on so long. What we're going to do now, with the magic of Zoom, 4 of us are going to drop out, and it's going to leave Araba and Jan just to go through just some questions and kind of start exploring these issues, and then we'll reconvene afterwards for the panel discussion. So again, thanks very much for attending tonight. I hope you get something out of it. We'll see you in about 30 or 40 minutes.
Well, thank you, Mike, for that introduction and for those case histories, which are quite shocking, and mainly shocking because they are commonplace. My name is Araba Taylor. I'm a barrister in private practice, and I also sit sometimes in the county court as a deputy district judge. And amongst other things, I do possession cases, that is eviction cases. And I also do accelerated possession, which some of you may know as no fault evictions. It's my pleasure and privilege tonight to be interviewing His Honour Jan Luber QC, whom I'm sure most of you will know from the book Mike mentioned, Housing Allocation and Homelessness, the LAG book. He's also a co-author of 2 other major housing law textbooks, defending possession proceedings, to which I often still have recourse as a judge, and housing conditions. And I'm sure that the name is familiar to you because for a very, very long time now, as a barrister, as a QC, and as a judge, Jan has been very active in this field, very vocal and very learned, and he has a lot of knowledge to share with us tonight. He became a civil circuit judge doing non-family, non-crime work, that is, in December 2015. And before that, he was in practice as a barrister at Garden Court Chambers. He's now a resident judge at the County Court in Central London, where I sometimes sit, and he's my boss, so to speak, there. And he also sits at the Mayors and City of London Court. He's since 2019, he's been the designated civil judge, was responsible for the civil work of 12 remaining county courts in London. And a significant proportion of that work involved some sort of landlord and tenant or housing work. He still writes the monthly column Recent Developments in Housing Law for the journal Legal Action, which some of you may be familiar with. And he's a patron of a charity of his own, which is the London Welfare Benefits and Housing Charity, Z2K. With that introduction, I would like to proceed on your behalf to ask him some questions about why he's involved in this area of law and what his experience has been. I should also say, I should have mentioned in the introduction, that he was responsible for drafting the new protocol for possession actions for court-based evictions. And we know that COVID has had a very serious effect on possession proceedings, some of them being halted, and that's been good for not making people homeless, but there have also been downsides from people who needed to be perhaps nuisance tenants. So this is an area where Jan has experience on both sides. So Jan, why did you choose housing and homelessness law when you were in practice?
Araba, let me answer that, but first say that it's a privilege for me to be joining you this evening and have an opportunity to discuss this important topic, as well as shining a light on the wonderful work done by the organisation that are hosting us this evening. My entry into interest in matters housing related began long before I became a barrister. I grew up as a child, a young person, in rather unsatisfactory housing in South London. I shared my time between a property on an estate of council housing in Lambeth and a privately owned property in the neighbouring borough of Croydon. Neither property was in good condition, neither had central heating, and much of my childhood was therefore spent living in rather unsatisfactory housing. When I decided that the law was going to be my profession, I went off to university to find that most people were interested in how you pass your estate by will, what happens when two ships collide on the ocean, and anything other than the real human issues with which my life seemed to be engaged. I was blessed at university to have as my tutor a person who became Professor Martin Partington, who is probably the country's leading specialist in matters of housing, and under his inspired guidance, I found that that was the area for me. So as soon as I was able to get to work as a lawyer, that was my specialist subject area.
And is it the case now that you're a circuit judge? I know you do some landlord and tenant and housing matters as a circuit judge. Do you still see much homelessness work?
Yes, there's quite a lot of housing and homelessness work for a circuit judge. It comes to us in three ways. First of all, circuit judges are the judges who hear homelessness appeals. Those are the appeals individual homeless people make against decisions taken by local councils on their housing applications. So we do those. The second type of work I do is appeals from district judges. As you said in your introduction, you sit as one of our fee-paid district judges, and unbelievable as it may seem, sometimes it is said that you have made mistakes. Not you personally, of course, but district judges generally. And when that happens, an appeal or right of appeal lies to a circuit judge. So sometimes I'm considering decisions on housing cases made by the frontline judges, the district judges. And the third way I see housing cases is that I have to, as a circuit judge, try the most difficult housing cases, those that are on what the lawyers call the multi-track, which are difficult housing cases raising points of law and that are going to take several days to resolve. When I'm run out of time doing those things and all the rest of my work, I'm also authorised to sit as a deputy judge in the High Court in what is known as the Administrative Court. So that deals with the work of judicial review, which sometimes covers housing cases as well. So although my ordinary day job covers the whole range of civil disputes, from neighbour disputes to personal injury claims and car accidents and ruined holidays, I also get a fair amount of housing work.
Thank you. I'd like to know how things are at the moment. What our experience at JustUs is that the fastest way into homelessness is losing a private sector tenancy. And I wondered, what effect do you think COVID has had on court-based evictions?
Well, I think it's right as a matter of the statistics that the most common reason for persons becoming homeless at the moment is the loss of a private sector tenancy. It used to be breakdown of family relations, but I think private sector loss of tenancy has taken over. Of course, the courts have a responsibility in that dynamic, because the way to lawfully evict private sector tenants involves, as you said in your introduction, going to a county court and asking for a possession order. A remarkable feature of our justice system in the United Kingdom is that we've stayed open for business during the COVID pandemic. So the courts didn't close in the first lockdown, we didn't close in the second lockdown, and we're not closed now even in the tier 3 areas. So civil justice remains available. And that means any private landlord, indeed any type of landlord or landowner, has been free to bring a claim for possession, notwithstanding that COVID is raging in the country. The government, as I suppose most viewers will know, took a policy decision that the work of the courts in relation to possession cases should be stayed or suspended from March until towards the end of September. So that happened, and all our possession work was paused. When the pause ended on the 20th September, we started to implement arrangements we had made during the pause to try and manage the large volume of work we thought we would have after that. And what has in fact happened since the pause ended on the 20th September is that the mortgage lenders have held their hand. We haven't had many homeowners losing their homes, and the social landlords have by and large stayed their hand as well, recognising the difficult situations people are in. So the courts have been quite busy since the 20th September in dealing with possession cases, but they're almost all possession claims brought by private landlords who are seeking to repossess their properties.
So would you say it continues to be the case that the loss of a private sector tenancy then is the key way into homelessness for people?
I think as part of the bigger picture, it probably is, but it isn't at the moment because very recently the government has taken another policy decision, which is that nobody will be evicted, even if there's a possession order against them, until the middle of January at the earliest. So to the extent that the life of a local authority has been in the past dominated by evicted tenants becoming homeless, that certainly hasn't been the case since March, and it won't be the case at least until probably late January, early February next year.
And that's because there's bailiffs attending at people's premises, is it?
That's right. The government decided as a matter of policy that nobody should be evicted over the winter period from the beginning of December until the 11th of January. And that restriction means that no bailiff activity and no high court evictions are generally taking place. There are some very small and limited exceptions to that. You mentioned earlier tenants and so on creating grave nuisance and so on. They can be evicted, but that requires a judge to certify that the case is of the requisite nature.
Okay. I'd like to ask you some questions about, again, something else that we see and that we experience in doing our advocacy locally. We're aware that even the Local Government Association is concerned about the phenomenon known as gatekeeping. And I would just like to know what examples of bad or unlawful practice you've seen down the years. And of course, you've been doing housing for very many years. And what do you think should be done?
Well, of course, that's a topic on which I can no longer speak with authority, because as a judge in the county court, I'm not concerned with the sort of cases which deal with behaviour of public bodies in relation to how they carry out their statutory functions. Mm. And my history in practice ended in 2015. Since then, the government has passed, or rather Parliament has passed, the Homelessness Reduction Act in 2017, the primary function of which was to overcome what had been perceived difficulties about the statutory authorities, local councils, getting involved at an early stage when a person faces the prospect of homelessness. So the idea or the aspiration was, certainly from 2017 onwards, that there would be much more attention to the needs of those who faced the prospect of homelessness at the earliest possible stage. And the focus would come off of the work that I had been doing as a lawyer, which was challenging the decisions at the end of the process. Mm-hmm. And it would be for others to say whether that legislation has worked and whether there has been greater intervention and participation in helping people at that earlier stage. It seems to me also that a very good barometer of that type of issue, how well are the public authorities doing, is the work of the local government ombudsman, because that is the body to which one should go if one feels that services haven't been provided in the proper way in terms of the service that a public body is offering. And on the topic you describe, I think broadly as gatekeeping, historically the local government ombudsman have had a great deal to say about how services can be improved based on their investigations of particular cases.
Yeah. Well, I'm sure homelessness reduction will be an issue that will come up during the panel discussion. And yes, and gatekeeping is an issue, I think, for us as a local advocacy charity, and certainly it's something that one reads about. Now, Mike gave us a case history about a young man called Matt, a young single man. And our experience is that single homeless people, especially men, seem to fall between the cracks when it comes to being accepted for homelessness or being found to be in priority need. And I just wondered whether you thought that the categories of priority need are working effectively, or whether they need to be looked at again as they were in 2002.
Yes, I'd like to answer that in this way. I mean, firstly, we've now got a situation in which we have an Act of Parliament, the Housing Act 1996, which defines categories of individual who have priority needs. It's not a hugely wide category, but some of the classes are broad. People who have children, people who are pregnant, and so on and so forth. The category which gives rise to the most controversy is the category which contains people who have a priority need because they are vulnerable for one of the reasons specified in the legislation. And it is that gateway to priority need that has historically caused the greatest difficulty. It's been there now for many years. It was in the original legislation in 1977, and here we are in 2020, and we're still having disputes about what it means and which people it embraces. The second way you can get priority need is under a ministerial edict, the priority need order. And that allows ministers to add categories of people into the priority need bracket. And I think the current order in England includes about 8 new or additional categories beyond those in the legislation. So, for example, you mentioned single homeless men. There is a special category in the ministerial order for single people who are care leavers or vulnerable as a result of being institutionalized. And then we have variation across the different nations of the United Kingdom. Some have decided that less focus should be made on priority need as a threshold to getting statutory assistance, and have decided that the focus should be on everybody who's homeless, because being homeless is being quite priority itself. Mm-hmm. So I think there are different views. That what I would say to anybody who's interested in this field is, don't treat the categories as closed. As I say, categories can be added by ministerial order quite easily if compelling case is made. And as we've seen from the domestic abuse bill, which is going through Parliament, governments can be persuaded to add new categories. And we're about to have a new category added of those who are victims of domestic abuse. Even if they're not vulnerable, they will get priority status. So there is, as it were, hope. It's not a fixed, locked box of preventing people accessing it.
And certainly, I think we see a lot of victims of domestic violence. They're often in priority need because they've fled the home with children, so they're automatically in priority need. But I think, yes, it's useful to be aware that the categories are going to be expanded. How effective that is, we don't know. When I was doing homelessness law in practice, we used to say that if you had 12 social, health and other problems, you would not be vulnerable. But if you could get to 13, then you might be. And it was always said with a very wry, disappointed air, because we had some very, very vulnerable people who just weren't quite vulnerable enough to get into that category. And looking back to your days in practice as a barrister, do any cases stand out for you that were particularly perverse?
Oh, absolutely. All the cases I lost were perverse. Only ones that I won were correctly decided. No, I tease, of course. Looking back now, I suppose the cases I did as a barrister in practice fell into one of two classes. By far the most common class was what might be described as the administrative mess-up type of case, where a public body would make a mistaken decision through bad practice, failure to consider relevant documents or issues or medical reports and so on and so forth. They didn't get top billing, but they were important for the individual people involved because they led to individual changes. I was very fortunate when I was a barrister to do some of the other type of work as well. And those were the cases which established important issues of law or practice in relation to homelessness, which then had to be applied across the board. And they will have helped, if they went the right way, large numbers of people to get better services than they previously did. So I was very pleased to be able to do something in respect to both of those types of cases.
What advice would you give to advocates like our caseworkers, like Mike and Shannon, who's going to be on the panel tonight? What advice would you give to them about how they can challenge poor council practices?
Well, it depends on the nature of the practice in question, but the first answer I would give is to try and respond with constructive criticism. That there are many things that are perceived to be unfair or not properly carried out practices. And it is extraordinary how simple a change can be achieved if one makes a constructive proposal. I mean, instead of sending out letters which say this, why don't you send a letter that says that? Or why don't you express this rather confusing paragraph in your standard letter in this alternative way? And it seems to me suggestions like that, modest as they sound, can achieve great change for individuals. Just to give one example from my own work, one of the issues about which I've been concerned for many years is the standard of communication of decision letters. Decision letters are sometimes very long. It's very helpful if they have paragraph numbers, because then when you're responding to them, you can say, look, at paragraph 17, you seem to have made this mistake. It took me about 3 or 4 years of being a judge and writing extrajudicially for everybody to move on to having long letters from homelessness officers with paragraph numbers. That's just sounds like a very churlish and silly example, but it's a sort of way in which service improvement can be achieved if one offers constructive criticism. If constructive criticism doesn't work, I would say to colleagues, yes, there are going to be cases where the law and legal remedies is what one wants. But if you really want service improvement, there's nothing quite as salutary for a public body as a formal complaint under their complaints procedure, or a complaint to the local government ombudsman, if it's a local authority, about the services they're providing. I tend to find that public authorities treat legal challenges as just something they can deal with and send off to their lawyers. But what really gets under the skin is having to deal with the complaints department or the local government ombudsman, who sends an official round and says, right, open that filing cabinet, show me the file on so-and-so. That can be much more salutary than a judge in 2 years' time looking back over something that was done and saying it was wrong.
Yes, yes, that's very helpful. And I think actually JustUs does take quite a lot of complaints forward. And yes, it does sometimes lead to great improvements in the services offered to homeless people.
One good example of that, Araba, is that a judge can never extract an apology.
Yes.
Many people who've been badly served, the thing they want most is a recognition that that's so, and somebody saying, I'm sorry. Yes. And you can go from the lowly county court where I work to the United Kingdom Supreme Court, and none of us judges have powers to make the other side say sorry. Yes. So if that's what your customer wants, your client wants, your service user wants, it may be there's a better way of getting it than going to the courts.
And I think also, in addition to the apology, sometimes you can get agreed changes in practice, and sometimes that's what people want. They want to make sure that what happened to them never happens to any other homeless applicant. And that again is something which an ordinary judge in an ordinary court, as you say, all the way up to the Supreme Court, doesn't have power to compel. But often a complaint will do that, and sometimes the complaint to the local government ombudsman will also do that. There'll be a recommendation about a further change in practice, and that can be taken on board. Now, one of the reasons that I signed up to JustUs, being a lawyer in private practice, is that the ethos and philosophy of JustUs is that the answers to homelessness are all in the law already. I think Mike began to say a little bit about that in his introduction. And our view really, which is music to a lawyer's ears, is that if the legal rules are followed, homelessness could be solved. Would you agree with that, or do you think there are parts of the law that need to be repealed or amended or strengthened?
Well, firstly, one should use the law, use legal resources, go to court, if there is a legal right to which you're entitled and which you've been refused or denied. And that's clearly right. But the lawyers and the courts can only force compliance with the law that is there. It's for the policymakers to decide what is the right law to lay down. Mm-hmm. I think, if I may say so, it's a little ambitious, even as a lawyer who's been doing housing law all his life, to think that law can be the solution to any major social problem. Look at just reflecting on the way you put the question to me. Assume that the Housing Act 1996 worked in every case exactly as it should. Yeah. What then would be the net result? That some might say that it would simply mean that local authorities operated the best and most efficient private rented sector letting agency that had ever existed. Because there is a very common misunderstanding amongst the public and amongst some advisors that if you go through the homelessness route, you end up in a home for life in a social housing property. That's never been the law. It wasn't the law in 1977 when all this was introduced, and it isn't the law now. All it means, if you successfully surmount all the legislation on homelessness, is that you end up with a situation in which a local authority has to find you somewhere to live. And that might well be in the private rented sector, which is where, as we said right at the beginning of this conversation, most people start. They lose their home in the private rented sector. And if the homelessness legislation works correctly, then they may well end up in exactly that situation again. So some would say, I don't say this necessarily myself, but some would say the effective operation of the current homelessness arrangements is simply to ensure a free access, very Rolls-Royce managing agency for letting private sector properties. Yeah. That's why when my colleagues and I wrote the book, which has been referred to already, we didn't call it homelessness law. We called it housing allocation and homelessness, because what we found is that the most desperate and vulnerable people whom we represented didn't want to go through a glorified letting agency machine to get another private rented sector tenancy. They wanted the security of social housing. And the only way to get that is by a successful application for a housing allocation.
Yes, I think we found, I think with homelessness reduction, that there are issues about people who are successfully housed in the private sector and then within a year or two are homeless all over again. And the fact that they may be presumed homeless, so they don't have to go through all the hoops for the second application, may be of very little comfort to them, because they're having to move again. And we know how displacement can be very bad for people. And they may not find suitable accommodation. They may still have to move schools for their children and so on. And the fact that the council has to accept an application from them isn't necessarily as great an advantage as it might be. Now, I know that Mike, who started our principal caseworker and founder of JustUs, who started off the questioning, he has some slightly meatier questions for you relating to the Housing Act 1996. So perhaps I could...
Yours were pretty meaty.
Well, different questions then.
Yes.
I can hand over to him before we move on to our panel Q&A.
Certainly.
And given that we've got Sarah here as well, I just wanted to pop back up as well, because yeah, if you've got an opportunity to ask 3 lawyers the same question, then I'm going to take that opportunity. And yeah, so this question I'm going to ask, there's a reason why I'm asking it here. It sounds like a technical question and it sounds like a very pedantic question, but ultimately I would say this question, if whatever the answer might be, is going to have a huge impact on potentially tens of thousands of people every year. And it basically, it's around the thresholds that people have to meet to kind of get certain levels of assistance from a local authority. So as I say, my question is long. I can't make it any more succinct, unfortunately. Hopefully it will make sense. So under Section 184 of the Housing Act, if someone approaches any department of a local authority and gives them reason to believe they might be homeless, they immediately trigger Section 184, so that the council then has to make inquiries, reach a decision, issue that decision in writing, and so forth. Now, there was a case back in 2007, I think, Owies v Birmingham, where essentially the judge in that case said it is almost impossible for a council to be approached for homelessness assistance and that duty is not triggered. So essentially if someone turns up, says I'm homeless, or they said I'm experiencing domestic abuse, or I can't afford my rent, all those things would potentially, or they would give the council reason to believe the applicant may be homeless, and therefore Section 184 proceeds. And then this is the kicker. So that was all a prelude. Section 188 basically states that if an applicant may be homeless, may be eligible, and may be in priority need, the council shall provide, make sure that accommodation is available for them. And this is where my question comes. Various cases have shown that pretty much any mental health issue, to use that example of mental health issues, could lead someone to being vulnerable and therefore in priority need. So my question, so a classic example of that would be Thomas v Lambeth, where the applicant had depression, been diagnosed with depression, and she was found to be in priority need. Now, so here's my question: if someone approached the council, said they were homeless, therefore giving the council reason to believe they might be homeless, and they basically said they had a mental health issue, or they'd been in care when they were a child, or they just left prison, or all those kind of categories that could make someone in priority need, would that in itself cross that section 188 threshold and give the council reason to believe that they might be in priority need? My question is how high is that threshold, or how low is that threshold that a person would need to, because things, you know, I'll give you some examples, and I will labour this point. My colleague John accompanied a pregnant lady. She was, I think, 30 plus weeks pregnant, visibly pregnant, and she told the officer that she was homeless. And the officer said, okay, well, you're going to need to show us a pregnancy test before, you know, we can help you out. And then so they did that. They jumped through that hoop. And so the officer said, no, that's not enough. I'm going to need to see the green book from your midwife before I'm going to accept that you might be in priority need. And so they did that. And then the officer said, no, I'm going to need to see a scan photo before I believe that you might be in priority need. Now, that's the reason I'm asking this question. And in one sense, that's the kind of the background of it. So again, it sounds very pedantic. But how high is that threshold, or what at what point would a council have reason to believe someone might be in priority need?
Yeah, and I wonder if you want to go first.
Well, the first thing for me to say, Mike, is that your question wasn't pedantic at all. But if you ask 3 lawyers that question, you may get a very pedantic answer. Yeah. And even more infuriatingly, if you ask 3 lawyers, you may get 4 very different answers. So let me have a first stab. Mike, in your question, you raised the references to a large number of sections of an Act of Parliament. The Act of Parliament you're speaking of is the Housing Act 1996, and Part 7 of that Act sets out the responsibilities of local councils in relation to homelessness assistance. I know you know that very well, but I thought that mentioning that would set a platform. Now, Parliament has decided that the questions about who gets what help should be decided by local authorities. And therefore, the legislation uses quite frequently the term, the local authority is satisfied that. So the local authority is satisfied that you are homeless, you are in priority need, your accommodation is suitable or unsuitable, whatever it is. That's the decision-making level. But as you rightly say, before anybody makes any decisions, they have to start their investigations, start their inquiries. And therefore, Parliament has fixed the trigger for the commencement of inquiries much lower than the decision-making level, because obviously one's got to look into things. And that is why the words you have used, reason to believe, have been adopted at that threshold level, rather than the higher standard, satisfied that. So in the government's code of guidance, which explains to local authorities how this all works, each time there is guidance given on the meaning of the words reason to believe, the guidance draws a contrast to the higher standard of satisfaction. That's when you know something and you can decide something. So take an example that you've just mentioned, not the specific case, but the generality. A person will be in priority need if the local authority is satisfied that they are pregnant, or they live with somebody who is pregnant, or they can reasonably be expected to live with somebody who's pregnant. Now, those are 3 discrete categories of priority need. You can get priority need for one of those if the local authority is satisfied. But in order for the local authority to know that, there's got to be an inquiry and investigation process. And all you need to raise in order to raise that question is reason to believe that you may be pregnant, may be living with somebody who's pregnant, may be a person who might in the future live with somebody who's pregnant. So one can see why in cases such as those you've mentioned, the judges have had to spell out that this is an extremely low threshold. It's just a trigger to looking into the question. So when I used to do training on this sort of thing, I always used to give the example of the person, take an example of a male who walks up to the counter and says, "Give us a house, mate, I'm homeless," and then keels over. That person has made an application for housing or for assistance in obtaining it, and has given the officer reason to believe they may be homeless because they said they were. So that seems a very silly example, but it I would say it applies in exactly the same way in a scenario, for example, of pregnancy. You go up to the counter, you're visibly pregnant, you say you're pregnant, well, that gives the officer reason to believe, one would think. Of course, there are going to be exceptions. There is the person who's going to come up to the counter with a large belly and say, I'm pregnant. And the officer is going to say, aren't you the same woman who did this last week and then took 3 pillowcases out of your t-shirt? Of course, there are going to be the extraordinary or exceptional cases like that. The person who is known to be an inveterate liar and so on and so forth, that they can be put to one side, but they are a tiny fraction. The general message is this is a very low trigger point for the starting of inquiries. And as you rightly said, if you might also give the local authority reason to believe that in addition to possibly being homeless, you are also possibly in priority need, then that triggers a duty to provide you with accommodation while the issue is being looked into.
Thanks very much, Jan. That's really helpful. Is there anything else you want to add to that, Sarah?
Yes, well, there are 2 slightly different trigger points here. So there's the trigger point for commencing inquiries, and that is extremely low, as you referred to, Mike, in our ways, and also in another case called Berry and Gibbons. It was said that by the mere fact of you making an application for housing assistance, you are already providing that trigger for inquiries to have to commence. There was a case a couple of years ago called Edwards and Birmingham, which asked all sorts of bizarre questions like, could you approach the refuse collectors? Could you turn up at the local authority leisure centre and so on? Well, I mean, of course, those are extreme examples, but if you're going to the right place and you're saying you're homeless, really, the local authority has got to start investigating. It's only a very short step further to then get to the point that there is also a duty to provide accommodation. Now, the duty that you referred to under section 1881 of the Housing Act is what is commonly referred to as the interim duty to accommodate. So it's the duty to provide accommodation or to arrange accommodation precisely before the local authority has made its inquiries, precisely before it has investigated the truth or otherwise of what you're saying, or the severity of your symptoms, or whatever else. And so for that reason, the courts have always said that it was a designedly low threshold. And of course it is. It's very difficult in cases of vulnerability, as opposed to pregnancy, for example, it's very difficult to draw any sort of hard and fast rules about what is going to cross that threshold and what isn't. But bear in mind that the comparison that is being made when we're looking at whether a person is vulnerable is between a person who does have the condition that is being claimed and a person who doesn't. So if you have some sort of condition which may impact on your, I don't want to say ability to cope, because that's not the test, but which is relevant to your homelessness, let's put it that way, so that you might be at a risk of some form of harm whilst homeless, then that's likely, I suppose, to cross that threshold. But we can't really say that the mere fact, for example, that you say I have depression or I have high blood pressure on its own, it might be enough, it might not be enough, and it's very difficult to say without knowing the facts of any particular person's case.
So essentially, you're saying there would need to be some kind of impact that depression might have on that particular person at that particular time for that to kind of start becoming a question for the of whether they've reached that low threshold. Is that? I
like I say, I don't want to sort of say too much about it. What I think I mean is that the mere label on its own is probably not enough unless it's a label which sort of by definition is going to affect a person's ability to deal with homelessness. So, I don't know, for example, somebody who's got ME or somebody who's got cancer or something where it's abundantly clear that the mere fact that you have that condition is going to make you vulnerable. But in very many cases, of course, that's not what we're talking about. So there would need to be, I think, a little more than merely reciting the fact that you have this particular condition.
Yeah. Okay. I mean, Araba, do you want to add anything to that? I mean, that's
you're going to get two lawyers agreeing, which is a novelty. But the point that I really wanted to pick up with is this obligation to provide temporary accommodation whilst inquiries are carried out. And we know that often what happens is people don't look at the person and see, oh, is this person giving me reason to believe that they might be homeless? They're thinking, we don't have temporary accommodation. And so really looking at the application from the wrong end, I think the threshold is very low, which I think can be a great burden for local authorities and for housing officers who are aware of the general context. So I think that's often where you get people being skeptical of a lady who is 30 weeks pregnant and saying, no, I don't believe it, I don't accept that. And that's probably where it's coming from. So I think what you often get is not the application of the law strictly in the strict sense, but you get people who are in the sector, who are aware of the restrictions in the sector, aware of the shortage of accommodation, whether it's temporary accommodation or suitable accommodation once people have been through the process, where sometimes you feel perhaps people have, I mean, I know we deal at JustUs with, I think, 11 local authorities, and you know that there's an issue of people coming over the parish boundary, so to speak, and they've come from central beds, they've come from Northampton, and they're in Bedford looking to make a homelessness application. And so one sympathises with the pressures on the system that encourage housing officers to feel, well, I'll start from the wrong end. But I think the threshold is very, very low. Certainly vulnerability is very difficult to assess. The known categories of priority need are often very obvious. I think you sometimes have issues with mental ill health because that too is on a vast spectrum. And somebody who comes in floods of tears may or may not be suffering from depression and anxiety. They may just be suffering the inevitable stress that we would all suffer if we're being evicted. Are they in that category of vulnerable person that this is directly related to their homelessness, would make them less able to cope with homelessness than another person? And I think those things do make it very difficult to assess. But yes, the threshold is deliberately low. When you've made your inquiries, then you can say, having made those inquiries, not satisfied. I think actually getting over the threshold, it should be much more straightforward and much more common. And we know the pressures everyone's under. I just wanted to say something in relation to what Jan said earlier about being the letting agency for the private sector. And it is really a very big issue, because we know that even temporary accommodation is often councils paying private landlords. And it's often that accommodation isn't suitable, but may nevertheless be very expensive. So I think that the issue of the shortage of social and public housing available, including for temporary purposes, is one of the very big drivers.
Mike, I wonder if I could say something about the remedy in those sorts of cases that you're talking about, because sure. You said earlier when you were giving your introduction that when you first started looking into homelessness, you didn't really realise that homelessness law was a thing, that it existed. And I think that seems to be an issue that a lot of people have, that actually you go to the housing options office and you get turned away, and it doesn't occur to most people that is a decision that could be challenged. So if I can give some sort of advice or reassurance, it's that those decisions can be challenged. They frequently are challenged, and cases like your client that was visibly pregnant, they are clear-cut cases that we would be on the phone to a High Court judge to get an order that day that there would be accommodation provided for that person. And these sorts of gatekeeping cases form a very large part of urgent applications to the High Court, because really, if you're going to be phoning up a High Court judge in the evening, you really want your case to be incredibly clear cut and straightforward. You don't want it to be anything complicated. You don't want to have to argue for any particular interpretation. And those cases, like the pregnant applicant, that is what we deal with, and there is a remedy available if only more people knew that it was there.
Yep. And I'm hoping, I mean, I know there's a real mix of people watching tonight, but I think there's I'm hoping that this is real kind of, you know, music to the ears of people who are, you know, voluntary sector workers who won't have ever heard of this stuff. And again, are often quite intimidated by the thought of challenging council decisions. I'm just aware, so I'm just aware that so far we talked about the kind of the law, you know, kind of the technicalities of some law and some of the bits and pieces. Shannon and David, do you want to kind of drop back in if you're still there? I'm hoping you are. Here we are. Yeah, cool. So, as I say, so tonight's event, I mean, it may well kind of fall short because we're trying to do too much. But for me, it's incredibly important that it's, you know, this isn't just a case of just some legal information. That this is actually kind of grounded in real life experiences that people have, as I said at the start, every day of the week in probably most areas of the country. And so, as we begin the panel discussion, I think we're going to return to some of the stuff we've already talked about. But I just really wanted to just start with that question. I know David and Shannon have kind of said it's okay to kind of talk about some of this stuff with them, but just really put that question out there of, you know, we've heard about the legal side of things, but what is it actually like to be homeless and to approach a local authority? Often you get seen in a customer service centre, which is open plan, and you're supposed to, you know, spill your guts about the abuse you experience and all the rest of it. And then you often kind of come against officers who know there's no temporary accommodation available that day. And so there's all kind of things that, you know, we can talk about, but I guess it'd just be really interesting to hear from you guys about what that actually feels like going through it. And I don't know, I mean, I'm nervous enough doing this stuff tonight. I know that, you know, me and Shannon have been fretting about this all day. So I don't know if you want to go first, Shannon, or whether you want David to go first. It's up to you.
I'll kick off then.
Cool.
It can feel actually really chaotic and traumatic. Like you say, often the centres are open plan. If you're lucky enough to be in a single room with someone, normally it's a tiny squished room, facing a housing officer by yourself when you're in a vulnerable position, and a position that is actually quite embarrassing to be in. You've sort of gathered enough courage and strength to ask for help finally, and then you have to justify everything. And you can have stacks of evidence in front of you saying why you're vulnerable, how you're vulnerable, why you're homeless even, and they still might not believe you. And that's a really traumatic thing to go through, to sit there and to not be believed that actually you might be homeless when you're telling someone quite an embarrassing, yes, I'm homeless, please help me, is really, really damaging. And I think that stays with you through the whole process, even when, if you're lucky enough to be awarded temporary accommodation, it's temporary. I know I found myself waiting till sort of 5 o'clock when the offices shut, because I knew I was safe that night. I knew I had somewhere to sleep that night. And I was lucky enough that my temporary accommodation was suitable for me, but not everyone is. And it's so important that, like Sarah said, people know that you can challenge these decisions. They're not hard and fast, black and white. You can challenge them if you feel they're wrong, but that is a lot easier said than done if you don't have someone on your side fighting for you.
Yeah, cool. Thanks, Shannon. And I mean, David, do you want to say anything about this one?
So I think it might be helpful to put some context as to why I ended up homeless, and then talk about what happened then. And this is a story that I hear a lot, or similar stories. So I grew up in a care system that was very different from today, very abusive, and it led me into doing all sorts of led me to a behaviour that was isn't perhaps good for me. But I started taking drugs. I then went into the army, spent a long time in the army, and I went on active service, so I've been into a war zone, if you like, and then came back out and spent another 18 years on drugs and got caught up in criminality and all sorts of stuff, and very much putting myself in dangerous positions. So when I came through all of that and was living on the streets of London, I went to my local authority and I pitched up, and my name is David Ford. I'm homeless. I've seen the light. Can I have some help, sort of thing? And they took one look at me, and when I mentioned that I was in the army, they took one look at me and said, well, actually, no. We think that you can help yourself, sort yourself out, and sent me out. So the two things here. The first thing is no one asked me at all about my past, and I had no idea how to present other than, hello, I'm David Ford, can I have some help? That was the first thing. And the second thing was the impact on me. So I suffer from mental illness. In the past, I've attempted to take my life a couple of times, and I'm stable now, but in the past there was quite a lot of problems. And so when they told me I had to leave the council, it was probably one of the most lowest points, if you like, in my life. And when people talk about experiencing homeless and going out there and doing that, you know, we'll go out and do it to raise some money, and they're not actually experiencing homelessness, because it's that feeling of absolute nothingness, and everything in front of you has disappeared. It's black. There is nothing. It is a frightening feeling, you know, incredibly frightening feeling. The way that I got the help and support that I needed wasn't from my local authority. The support wasn't directly from my local. I got it from the community of people that were out on the streets, who I was with, who then told me how to go and present myself at the local authority. You know, so there was never any questions, it was just assumed, because you're in your 40s, because whatever, you're male, away you go. And actually, I had quite bad mental health problems and stuff. And again, like Shannon said, you then go through this process, this interview process, with your whole life in a Tesco's carrier bag, and what's left of your shattered dignity and self-esteem in another little bag that's dragging along the floor, that's got holes in it, and it's a pretty rough time. And there's a comment in the comments there on Facebook about 80% of people accessing the homelessness assistance have mental health stuff. If you go and have a look at Hard Edges, when we researched the guys who with multiple complex needs, 85% of them were talking about childhood trauma and mental health issues, and yet actually you go and try and talk to a local authority officer about that. I was out doing some outreach recently. I was meeting some of the guys out there, and so obviously mental health problems, and I know a lot of them have had similar problems to me, and yet trying to get some support from a local authority, it's a different thing.
And just to the Hard Edges is a study you were involved in, wasn't it? I just wonder, I'll get my admin help assistance here, just to pop that link into the comment section if I can, because I think it's you know, I'll say it, so I might as well say it now. It's very easy to go out and give people who are on the streets, you know, hats and gloves and soup. It's much more difficult to fight for people and to actually get hold of these issues, and actually it does require a little bit of homework sometimes. And actually I think that Hard Edges report is one of many good places to start and actually read through and kind of just to understand some of those issues going on. And again, I've done a dreadful job of facilitating this, by the way. I haven't introduced people properly. I'm really sorry about that. And also I haven't kind of, there's a few things I wanted to say at the start, and that is one of those things is that when we talk about homeless people, it is a very broad term. You know, legally, when we talk about homelessness, we are talking about not just people on the streets, we're talking about people in night shelters, we're talking about people in refuges, people experiencing domestic abuse, all those kind of things. So in one sense, I don't even think we have the language to really kind of talk about this stuff accurately. But yes, I mean, you know, I think that's helpful going. Hopefully that makes sense going forward. I'm going to ask a question, and initially it's going to probably be directed at David and Shannon, but I'm sure the others will kind of have some thoughts about this. We often hear people say, Yeah, but they choose to be homeless, don't they? Most people out there choose to be homeless. Have you guys got any thoughts about, or any kind of comments to kind of come back on those those views? I know, David, I saw a hand there. David, do you want to go first? I know you. Yeah.
You know, wind me in if I, you know, after. So there's a couple of things. As human beings, as we trot along in our little world, we make the best choices that we think we make choices based on the best choices that we think are available to us at any one time. And if the choice for someone to live on the streets, that's about how bad the choice or whatever it is on the other side, you know. We did a survey, so that's where that choice bit comes in, and that's about people being forced into that choice because there is nothing else. We did a survey at Expert Link when everyone was moved into the hotels at the Everybody In project with COVID coming in and stuff. And there's always been this myth about, yes, that people choose to be on the streets. Well, we did a survey, and two people out the whole survey, and it was a nationwide survey, two people wanted to go back onto the streets. But again, that was because they thought that the offers that they were going to get weren't good enough. I have to say, I have done outreach up and down the country. I've interviewed thousands and thousands of people, and I've only ever met one person and had a conversation. One person. So I don't think it's a choice that I think if you want to use the word choice, it's about that choice being forced on people. Not a choice that people make voluntarily.
Yeah, cool. And I mean, does anyone else want to come in on that as well? I mean, I think an observation from doing casework is we've only worked with a very small number of people who are actually intentionally homeless. Lots of people are told they are, but when you look into their situation, it's very clear, even from a very basic legal point of view, they're not. So again, you know, advocates out there always challenge intentional homelessness decisions if there's any merit at all in it, because there's a lot to it. But I just wonder if anyone else wants to kind of give an answer to that question as well.
I wanted to say something. So I think intentional homelessness is a very different concept from choosing to be homeless. Unfortunately, although the words are similar, they mean really very, very different things. Intentional homelessness is a sort of legal construct which is about deliberate acts which cause your homelessness. But when we talk about people choosing to become homeless, I think we might be conflating homelessness in general terms and rough sleeping. And of course, they're completely different things. And the vast majority of people who we would regard as being homeless as a matter of law are not rough sleeping. But even amongst those people who the perception might be that they are choosing to sleep rough, I think we do have to be realistic to acknowledge that the people who experience the worst aspects of homelessness, so the people who are long-term homeless, the people who are rough sleeping and so on, they represent, in my experience at least, and I would imagine that the statistics back this up, people who also have additional issues apart from simply not having accommodation. So they're people who have mental health problems, and they are people who lack family support, people who might otherwise provide them with accommodation, who might otherwise provide them with a sofa to sleep on or whatever. So they are people who have all sorts of other problems as well as not having accommodation. And for those people, I mean, I've certainly had clients who have chosen to sleep rough, but it's a choice which is driven by fear, by mental health problems, by addiction problems, and other things which drive the person into that choice, as opposed to being a sort of free lifestyle choice is one way that I've heard it be described recently.
But Mike, can I just add to that? Because that's a really important thing, this whole thing about choice. And as one of the things that things that we can celebrate with the Everybody In campaign and getting everyone, all of sleepers on the streets, and the big takeaway for me was there was no conditionality. So there was none of these hoops that you had to dive through. None of these, you've got to do this, you've got to turn up here, you've got to go to this recovery thing, you've got to go to a mental health thing, you've got to go and see. There was none of that. All of that was taken away. It's, we need people into accommodation so they can isolate because of COVID-19. And what happened is people went in and they stayed in. Well, there was no conditionality. So that absolutely dispels this myth that people want to be on the streets, you know. It's about that place where they're forced to, where they have no choice because of the conditions.
Yeah, and Shannon, I just saw a hand there as well. You want to go to something?
Yeah, so just on the back of that, I think another point to make with the Everybody In is it's not 28 people in one tiny room, like squashed together like sardines in a tin. It's people have their own space. They're treated like humans, a little bit more than perhaps they might have been before this. And I think just to echo David's points on choice, I think 2 years ago when I was homeless, if you'd asked me, I would have said, yeah, I'm choosing to be homeless. If you had asked me what my mental health was like at that time, I think I probably would have said quite poor. And it's that choice being forced into your hand. And who wants to admit that that's their best choice? So it's almost a defense mechanism to go, actually, yeah, I chose to be homeless, because you don't want to admit to the fact that you have been led down this path to something that is actually quite often traumatic and not fun.
Yeah, I mean, I think, well, I'm not. I mean, I think it's interesting to see just the kind of this tension between effectively, you know, the duties that councils owe and the kind of the experiences that people have who are homeless, and that kind of that tension and the lack of housing stock, which essentially drives a number of these issues. And I hearing this kind of stuff, it just for me, it just kind of emphasizes how this tension and this kind of, you know, the options which are available to people, it shouldn't be left to the most vulnerable people in our society to kind of to carry this tension. You know, it should be housing authorities, you know, MPs, all those people higher up the chain that should be losing sleep over this issue, rather than, you know, as I say, the people who are often the most vulnerable, the people who've got the least amount of support available to them. I'm just
one thing about intentional homelessness, which is that for me as a lawyer, it's changed over time. I think when I started in practice, local authorities were very quick to find people intentionally homeless, but it was always a policy reason. If you read the parliamentary debates, you can see that it was brought in because it was felt that otherwise councils would be swamped with applications that they had to meet. So a test of intentionality was brought in, and it wasn't true everywhere. It wasn't true in Scotland. But then there was more housing stock, but a lot of it was not as good, but it was felt at least they would have a roof to put over your head. And it was acknowledged that in England and Wales, there just weren't enough roofs. And so there had to be some kind of barrier. And one thing I have noticed is that, for example, when I was in practice doing this, if you couldn't pay your rent, that was, and you had been evicted for arrears, that was often regarded as intentional. I think now people are recognising, partly because private rented sector tenancies are so expensive, that the fact that you couldn't pay your rent may not be your fault. So I think that it is clearly a policy issue, and that's where it's related to. The other thing I wanted to say was that a lot of our service users are criticised for not engaging with services which are there in theory to support them. But a lot of them will say that it's because the root of their trouble, it's not the addiction, and it's not the antisocial behaviour. The root of their problem is childhood trauma, and nobody is talking to them about childhood trauma. That's not because they're fresh out of prison. It's not because they're suffering from depression or some other mental illness. And they want people to tackle the root of it and not the symptoms. And we still don't have those support services around, and it is noticeable, I think, very much in Bedford, where we did have everybody off the streets in a hotel of some description, that those people really settled down, as Shannon says, when they had their own space, and there were no conditions attached. It was simply, we're not going to let you stay on the streets whilst COVID is raging.
So I think that leads on to another question that we've been asked, and that goes to kind of ask questions about the previous system. So, you know, before COVID hit, there was hostels, you know, certainly in Bedford, there's a lot of hostel places, and I know it's the same around the country. And yet it seems, you know, certainly seems to me, and this is going to be a leading question because of what I'm about to say, but it seems to me that many charities were forced to kind of look at economies of scale. So they kind of almost had to see how many people can we squeeze into this room to make, you know, to be able to kind of make ends meet. And that kind of led to, you know, entrenched rough sleepers. And for me, we need to see, you know, people who entrenched in that lifestyle as a product of homelessness services as well. They are there because homelessness services haven't successfully ended homelessness for them in whatever way. And I know there's like other complexities to it as well. But you know, what needs to change? You know, COVID is going to go away at some point, and we're going to be left with hostels. We're going to be left with night shelters, which may well end up reopening. What do people think needs to change about the approach that you know, that services deliver, you know, the way they deliver the support to people? That was a long question. I should probably make it more succinct. Sorry, David.
No, but I think it's not. But I think one of the problems we have is that so a lot of the services that are delivering this are commissioned by local authorities, and that in itself then is do you bite the hand that feeds you. So they're less likely to challenge policy or anything within it from local authority if there's a chance that they might lose their the funding, you know, for their service. I mean, I see that I see where some amazing, incredible people out there doing work, and I'm absolutely sure that that if they could, they would push their local authorities further. But services, perhaps, you know, we don't want to lose a contract, especially when it's paying lots of wages. I think that's one of the challenges.
Yeah, I mean, and I'm going to wait to see if anyone else wants to say something at this stage, because there's a point I want to jump off the back of that one, David. But does anyone else want to kind of, you know, that question of what do services in general need to do differently? And I know that's a broad question, but are there any things that, you know, we think are actually possible that services could do quite easily?
I think for me, services often fail to treat people as individuals. They see maybe hundreds of people coming in with similar issues, and instead of taking that one individual, that one story, and treating that person as who they are, they're treating them, oh, that's like such and such a person, we'll treat them the same way, they will refer them to the same thing. And it's that blanket approach towards people who are individuals and have different needs that could do with changing.
Yeah. I'm David, I'm trying to ask a question that would bring you onto your awful example, if you know what I mean. I'm just trying to think, because in one sense, one of the ways that you might be able to kind of challenge that approach of services, of having that blanket kind of policy, and you know, often kind of fairly humiliating and just kind of difficult circumstances people are expected to live in whilst they're in these hostels. David, you're massively, you know, really kind of pushing co-production, and I know co-production means different things in different areas. Do you just want to give a real kind of elevator pitch of what co-production is? And if you want to use the awful example, you know, feel free.
I'll use the awful example for you, but actually, so some of the benefits of co-production, there's lots of them, but one of the benefits is transparency, and absolutely that helps to stop or eliminate a lot of the stuff that we're talking about, because everything suddenly starts to become transparent and everyone's accountable for stuff, you know. But the story that Mike's talking about is a guy called Kurt Lewin, who's a psychologist back in the States, very prominent and famous psychologist during the war years. And during the war, pretty much here, everywhere around the world, there was food shortages and rationing and the like. And to help the war effort over in America, what the government decided to do was that they wanted to encourage the American households. So, and they phrased it as good old American housewives to use offal as part of their daily diet. So for those of you who don't know what offal is, that's the innards of an animal, so the heart, the kidneys, the liver, stomach, even tripe and things like that. And they wanted to encourage them to use it part of their daily diet. So they rang up or called in Mr. Lewin and said, look, listen, this is what we want to do. How do we do it? So he set up 2 control groups. The first one he went along to, got out his PowerPoint, I guess, or his equivalent of from the day, and his slides and what have you, and basically gave everybody a lecture on why absolutely they must use offal as part of their diet. It's part of the war effort, and the like. He went along to the second control group and he said, right, everybody, look, this is the situation. What resources and what skills and what talents have we got, and what do we know, and what wisdom can we bring to the table? How do we use, what recipes have we got? How are we going to use this offal? And everybody got involved and came up with ideas and things on how to use it. He went back at a later date to do his check, and he went into the first group, and out of the 100 people that he'd got in the room, whatever, 2% had started using offal as part of the daily diet. So this was the control group that were told. He went along to the second control group, and out of the 100, there's 37% of people had started using offal as a daily basis, and that's because everybody had been involved. They knew what it was for. There was nothing hidden, and so everyone got together. Often when we talk about co-production, people use the lack of resource for co-production, which is basically working together, as an excuse not to do it. I mean, that's sort of the Kurt Lewin story knocks that one away, I think, bats that well away. And I think that, Mike, you're involved with one of the groups that we have, and there's a lot of stuff that we do, and it's trying to get that co-production so that actually we can get local authorities, services, and people using services working together to design the services, the policies and delivery and all that sort of stuff, so that we can knock out some of the challenges through that transparency, if you like, that affect people who have had similar experience or are having similar experiences right now to what I had.
And I wonder whether actually going forward there's an opportunity for the legal sector, for solicitors, to be part of that solution, because in my mind every night shelter should have a solicitor on the team, so that everyone comes in, they get legal assistance, and essentially it should just be embedded within that sector, and it's kind of done together. I mean, that's probably another conversation. I've just seen we've got a 1-2 question here. The first question, I don't know if you guys are going to be able to answer, but it does lead to a second question, which I think we will. So essentially the question is, and we've seen this, effectively, if a council was to gatekeep someone who'd approached them for services, and the local government ombudsman finds out that the council did wrong and basically recommends compensation, often that amount of compensation is actually less than the council would have had to spend on housing that person in the first place. So the first question is, why is that? Why are fines not much greater to kind of stop councils kind of doing it? And I'll then give you the second question once we had a few answers on that one.
I think I can probably help with that one.
Yeah.
All of the ombudsman, or all of the different ombudsmen that there are in different areas, all give relatively low awards. And that's because really that's not what they're there for. They're not there to assess your loss. They're not an alternative to bringing court proceedings. They're there to effectively give you an apology and to recognise the injustice that you have suffered. So yes, they are low, and that's just the way it is. There isn't really another mechanism in terms of any losses or distress that you suffered for if the various duties under Part 7 are not complied with. So it's well established that there aren't any damages available. You can't bring a civil claim for example, the fact that you were not accommodated. And we were talking earlier about a woman not being recognised as being pregnant. I mean, I have had to advise negatively on a potential damages claim for a woman who lost her baby very late in her pregnancy because she had to sleep on a park bench whilst she was heavily pregnant. I mean, it's very, very distressing, but there isn't a remedy for that. Now, there may be some other sort of remedy. So, for example, I've been successful in having a discrimination claim, which is related to the way that homelessness application is dealt with. So there are other ways in, but there's no damages for the fact that you weren't provided with accommodation, for example. And yes, it's terrible.
And then Jan.
I just wanted actually to ask Jan whether this is something that you come across with perhaps damages which can be very, not token, but certainly not very high for judicial review. So if you bring a successful judicial review, sometimes we know that there are circumstances in which compensation can be paid. And I wondered if that was something that you dealt with on the bench.
Well, let me try and answer that point and also the underlying question which has been posed to us. But can I preface what I'm going to say by, and you'd expect me to say this as a judge, just introducing some balance here. We've been talking because of the work we all do, which is seeing people with particular difficulties and bad experiences, about a service which it is our aspiration normally works well. It's been a bit like having a discussion for the last hour and a half about the health service and only focusing on the things it does wrong. And we have a marvellous health service, and we've got to remember that the majority of our public services, we hope, work well. This discussion, for obvious reasons, has focused on when things go wrong. So let me go to the questioner first. Low levels of awards by the Ombudsman. I'd say two things about that. First, the Ombudsman in the homelessness field has been particularly good at ensuring reasonable levels of recompense. Just to give you an example of that, it is an absolute statutory prohibition, it mustn't be done, to place a family with children in bed and breakfast style accommodation for more than 6 weeks. That's the absolute maximum. Yet we have at any one time in this country hundreds of families who are there for more than 6 weeks. The Ombudsman has been extremely good at making awards at a daily rate for every day that the family stayed more than the statutory maximum of 6 weeks. And there you are getting proper recompense for the families, reflecting that they are having the experience that's exactly contrary to what Parliament required, and that requires proper compensation. The second thing to say is that the outcome from an Ombudsman investigation is often incalculable in financial terms, because what in fact happens is that the system changes, which is what, as Araba was saying much earlier in this discussion, is what so many people who've been aggrieved by poor service want. They want an apology. They want, even if it's a token payment, a bunch of flowers or whatever, to have a smile back on their face. But most importantly, they want to know that nobody else is going to have to go through what they've gone through. And that's of incalculable value. In relation to Araba's supplementary point, well, what about the levels of damages and compensation awarded by our courts in judicial review? Well, as Sarah's explained, it's very unusual to be able to get financial recompense when things go wrong. When they have awarded recompense, it has usually been on the basis that somebody's human rights have been infringed. And there, I'm afraid, we've taken our lead from the master, from the European Court of Human Rights, which has itself adopted the approach, slapping the hands of the wrongdoer, pointing out they've done wrong and saying, don't do it again, is by far the more important remedy than the relatively modest amounts of compensation that are awarded.
So this kind of leads on to the second question that comes after this, which is, so I'll read it out because there's two elements to it. So first of all, should we campaign to amend the Local Government Act to include sanctions for local authorities who ignore the law? And I know that answer has kind of partly been given already. But then it goes on to say, more broadly, what is the balance we should strike between legal action and political activism, both locally and nationally? I guess to see to see kind of the change that we want to see. So does that question make sense? So I mean, let's focus on the second half of it. So what balance should be struck between legal action in terms of kind of, making complaints, going to the ombudsman and so forth, and actually trying to, see political systems change? What's more likely to actually solve the issue, I guess, is the question.
I think the issue really for me as a trustee of JustUs who used to practice in this field and came to JustUs because of that, what I see as the real problem is the problem which everybody knows, which is the shortage of housing in the country. And this is true of all types of accommodation. And it's also true that those types of accommodation which are available are often very, very expensive. And we all know of young people who think that they will never own their own home. We know of young people who only own their own home because they have the bank of mum and dad to help them along. And we know of people who are on waiting lists for public or social housing for years and maybe decades. And I think that's it's a difficult issue because we feel that no political party has really focused on this, or that those who do are minor parties that don't get into power. And we feel the two big parties who've both got into power, neither of them delivered on either public and social housing or private housing, and affordable housing, so-called, is often simply not affordable. I mean, the 20% off may be a lot to the developer, but the young people starting out in life, it isn't a big enough deduction. So I think it's difficult because some of us are in a professional position where it's not possible to campaign. And if you want to campaign for more housing, which is really the ultimate solution, it's very difficult to see how that can be achieved. I think looking ahead with post-COVID, I wonder if the money's going to be available to do any of those schemes, which are crucial to really ordinary people who may end up in the homelessness system, perhaps on a revolving door basis. But I think it's very hard to see. And I think it's not so much political activism in the sense of perhaps going on marches, but I think it is very much an issue that we need to perhaps raise with our councillors and MPs and try to get the big political parties to do more. And it's one of those things that they always say they're going to do more and they recognise the need, but it's actually hard to deliver.
Yeah. I mean, I think that's, again, you're kind of making that point. It's very easy to get out hats and gloves, but actually to turn up at your local council meetings and kind of get to know the issues well enough to raise the issue more widely is more involved and it takes longer and is certainly less interesting. So, but has anyone else got anything to say on that question in terms of what are we to do with this kind of current issue?
Well, there were two separate parts to that question, weren't there? So that the first was about sanctions for local authorities, and I think I would quite strongly resist the idea of sanctions. Local authorities are public bodies, and the money that they spend is money that isn't being spent on people's care, on collecting the bins, on running libraries, and all of those sorts of things. And so the idea that they should be punished is that's not a proper approach in my view. But better to think in terms of remedies. And of course, there are remedies for a local authority where a local authority is not complying with its duties or not performing its obligations properly. So we've already talked about the local government ombudsman. We've mentioned briefly judicial review, and if I can just explain briefly what that is, because I'm conscious that there will be people listening who sort of have no concept of what public law is or the idea that you can challenge public law decisions. So judicial review is a challenge to the lawfulness of a public law decision which a public body takes. So whether that is a decision to send you away, whether that is a decision to put you in particular accommodation and so on. So there is judicial review available. There is also a statutory review process under the Housing Act. And if you're unsuccessful on a review, you can then appeal to somebody like Jan, who will then make a decision. None of these solutions are perfect. There's the issue of knowledge, which we've already talked about. There's the issue of access. Very many parts of the country do not have legal aid solicitors that can take on these cases. But of course, more and more of this work is now available remotely, so that it hopefully, one positive side of COVID has been that sort of advice might be more accessible. And a further problem is that when we talk about appeals to the county court, or we talk about judicial review, it isn't a wholesale challenge to whether or not the decision was right. So somebody like Jan is not being asked to decide whether a local authority were right in finding that somebody was intentionally homeless, or right in finding that somebody is not in priority need. It's a technical issue about whether or not all the public law protections that are in place, the procedural requirements that there are, whether they've been followed, whether the law has been correctly applied. So there are remedies out there. None of them are perfect, but they do exist, and there needs to be more awareness that they exist.
That's helpful. Again, that would be something I'd wish I'd have known back in 2005, because I think I'd have probably done a little more useful stuff in the meantime. I'm just going to do a couple more questions before we finish, guys. I appreciate you. It's been we're getting up to 9 o'clock. I know. I think it's obvious that I've been very harsh on housing officers in general, and I guess I haven't really kind of cracked how I kind of articulate that. You know, there is undoubtedly the majority of housing officers are good people. They do the job because they want to help people, and there is that resource issue that comes in. I guess, and I know some housing officers are watching. I just wondered if anyone had any advice. You know, for those frontline workers, you know, they turn up at 9 o'clock. They're on duty. They're going to see 30 people through the doors that day, and just before they go out on duty, you know, they're told, well, do you know what, guys? There's no temporary accommodation available today. Off you go. You know, what can they do in that situation? You know, and I know what they do is they try and do everything they possibly can to kind of do the right thing. But you know, what is there? What else could they do to kind of get out of that situation where they're essentially, you know, inadvertently pressured to do something which, you know, to not follow the law?
Well, we do have protection in this country for whistleblowers, is one thing to say. If you're being told that you can't provide temporary accommodation for people because you don't have any available, you are being asked to break the law. That there's no two ways about it. I mean, I can't give employment advice to people in that situation, but we do have some protection for people that are in a position of needing to disclose that sort of information.
And are there kind of things available which are kind of maybe less extreme? You know, I mean, I always wonder what would happen if housing officers just went on strike and said, well, you know, we'll come back to work when we've got enough resources to do our job properly. But I don't. Yeah, that's never gone down well with anyone I suggested it to. But Arabas, you got your hand there. Do you want to? Yeah.
What I wanted to say, I used to deliver in-house courses from shelter to local authorities, and the thing that always struck me about the staff was that they felt frustrated. And this was a long time ago. This was 2001, 2002. And even then, with the resources available then, which have since reduced, the overwhelming impression I got from the housing options staff who used to come to those courses, which I don't know if they happen now because they were booked from shelter and they were delivered in the council chamber of a local authority, so people didn't have to travel and they could be called away to their desk if need be, and so their bosses were happy. But the overwhelming impression I had from all those staff was that they were very frustrated because they couldn't do what they wanted to do. Some of them felt that they got people who were taking liberties. You know, you have the homeless applicant that you're sorry to see him again, but most people really wanted to do the right thing and they were really hamstrung. And I think it is very hard for them, perhaps when they've made a decision which has to be approved by a manager and the manager vetoes it and those sorts of things, or the manager says, I'd love to support your decision, but we just haven't got the accommodation today. Please just send them away with some leaflets. or get them into a hostel. I think it's a very difficult situation, not of the employees making. And I'd just like to say that, because I know there are people who feel very much that they're beleaguered and they're frustrated because they would like to do something that they're not able to do. I haven't got any solutions. My ultimate solution is really, as Jan said, to have more housing stock. We're a long way from that, and it is a very difficult situation for some housing officers. I think it is also easy to respond to that by becoming hardened and just, shielding yourself against the sea of humanity that washes through the housing options department day after day. But you can't help, and that's perhaps where you get to Shannon's situation, where instead of seeing somebody, an individual Joe Soap with depression, you just think all depressive people are like this, I'm going to treat all of them the same. And I think it's very understandable. I don't have an easy solution. I think a lot of it is economic and political, but we can only operate within the law.
Yeah.
So again, I've not got an ultimate solution, but however, you're so right, and I think Jan's mentioned it, you mentioned it, Mike. There are some incredible people out there working in our sector, whether they're housing officers, frontline workers, services, faith group volunteers and leaders. There's some amazing people, and they're all coming from a place of wanting to help. So they're coming from really good places, regardless of where they are. I think one of the challenges is that why we end up fighting a lot is there's so much tension within the system, and we're all fighting for our little bit, and we're fighting for this mental health part over here. We're fighting with services over here and allocate, or we haven't got enough properties and what have you. So there's all of these tensions, and what tends to happen is that those of, as I used to pitch up at my local authority, once I knew how to pitch up and bang my hand on the table and all that sort of stuff. I think one of the answers, or one of the ways that we can start to find the solutions for this, and maybe, Mike, the solution might be that everyone agrees that all housing officers or local authority officers go on strike and we all march on Downing Street. I don't know, but I think one of the ways we work out the solution is we come together and work it out and not fight amongst each other, trying to get to these points. Mike, you made a comment earlier about the legal profession being involved in co-production. I mean, how amazing would it be if we had somebody from the legal profession, somebody from the local authority, local service deliverers, and lived experience, those using services, coming together to design and work through the policies and servicing, because they're all having an input and all bringing their part of their wisdom and their experience into that solution. And I think so. I haven't got an ultimate solution, but perhaps all working together might be helpful.
Yeah, and I think there's actually some very practical ways that can be done. I mean, something we're hoping to work on locally, and it'll be new to the local authority, but it's something kind of up our sleeve, is we're hoping to kind of work together to kind of formulate some sort of policy around domestic abuse, particularly since the law's changing. But actually, councils have for a long time needed to have robust policies on how to deal with people who are experiencing abuse. And I think you could quite easily get some really incredible people all together and do something like that. So, I mean, I think that's that. And unless anyone wants to say anything on that one, I'm going to just close with one more question.
Sorry, can I just add something to what David was saying? And this is a bit of sort of micro advice, which isn't going to change the world or alleviate homelessness or anything of that nature. But if we're talking about this idea of co-production, or at least of cooperation, my advice to anybody either applying as homeless or supporting someone who is applying as homeless is ask for what you want, communicate, ask for it, explain what your difficulties are, explain if you need something to be done differently. Be as engaged with the process as you possibly can be. One of the innovations of the Homelessness Reduction Act was personal housing plans, which were supposed to have been a sort of joint activity, which was aimed at everybody working together to ensure that a person is provided with homelessness. It hasn't worked out that way. Most personal housing plans that I have seen are absolutely abysmal. They contain 1 or 2 steps. They're done from a template. Actually, if there are things that the local authority should be doing, say so. If the local authority has got it wrong, say so. If you think that they've done something wrong, say so, and just participate in the process as much as possible. And this is definitely with my lawyer hat on, leave a paper trail. Communicate by email as much as possible.
Yeah, I think it's a micro advice, but it's also very helpful. I mean, I'm just going to really kind of draw things to a close now. I know some people have kind of got some other important stuff to get on with. Again, I think a lot of people watching this are going to be lay people. They can be, working in, as I say, hostels, kind of services like that. Is there any kind of, simple advice you give to them to support people access this assistance that's available to them, through the law?
Be brave.
I think that was just what I was saying, really. Although if I would expand on one thing, it was, I said, if you think that things need to be done differently, ask for it. Well, one way in which that arises is people with disabilities who need things to be done a little bit differently. And again, you really have to ask for it. But this might arise in lots of different sorts of ways. So, for example, a person with autism really might not be in a good place to be being told that they should turn up on the day of eviction and wait and see what is available. A person with autism might need a much more planned, much more timely, much more ordered transition into some sort of interim accommodation. There are many different circumstances. It might be that a person has a need for wheelchair accessible accommodation, which we all know is going to be very hard to find if a person is just expected to pitch up on the day. So again, asking in advance to explain why you need your application to be treated a little differently, and just maintaining that sort of communication and understanding that there are remedies available if it isn't done properly, and of course one would hope that it is.
Jan, have you ever summoned the Director of Housing to court to explain a series of bad decisions? I know this happened to Newham in one case that was current when I was in practice. I just wondered if you ever do that and insist that somebody right at the top come and explain, because of course often they're far removed from the decision that their frontline housing officers are taking.
Certainly a power that the courts sometimes have and can use, Araba, and in an appropriate case one would do that. But can I just answer Mike's general question? I think it's a good question to close with. What tips can we give? If I would give one tip, it's this. If you think you've got a legal problem, don't try and fix it yourself. In the same way, if you've got a problem with your car, get a mechanic. If you've got a problem with the law or your legal rights, get a lawyer. And if you don't know how to, go to an organisation like the organisation that's hosting this meeting this evening. They will know who the lawyers are in the area who do this sort of work and will do it on legal aid. They're called solicitors with housing law contracts, but the individual will best find them through going through a local advice agency and saying, who can you fix me up with an appointment?
Cool. I think on that note, we're going to call it the end of the evening. Once again, I've been a terrible host throughout, and I'm sorry for that. But I just really appreciate. I've peaked. I'm never going to have this group of people in the virtual room again. I found it, in many ways very interesting, and I think it's going to be something which I'm going to be pondering about. And I'm hoping that people who've come tonight are going to have the same experience. Really, again, get a decent housing law textbook. As I say, Jan's is a very good starting place for that. Go look into things, go Google things, go and learn more information, because that is going to be the thing that will make the difference for the people we're trying to help out. So I hope you all have a very good Christmas. Thanks again for your time this evening and just being really kind of sprightly and everything. Thank you this time of day. I wish you all the best. Take care, guys. Thanks very much.
Thank you.